These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
If something is in parentheses, it's a reference, it's not there. The parentheses in the typed or the written language is the equivalent of a box. The two ends are there, but it's boxed in. So it is not there. It's only there as a reference. It is not part of it.
And you've seen lots of application in different government forms, people forms, insurance forms. You see boxes all over a form.
Or parentheses around a certain word.
They're not, technically it's not there. So remember that.
Okay.
Go ahead.
So in a court building, there are individual courtrooms. The courtroom is a box within the box of the building.
Does what happened in one courtroom affect another courtroom?
Not at all.
Because it's in a box,
not
right?
The same case.
Okay.
Got to go within the box.
Within that box. So you got a big box and you got a lot of boxes in it.
The courtroom is a box, but then it's divided in outside the bar, inside the bar. So now you got two boxes there. Outside the bar is public. Inside the bar is where the court business is going on.
Private.
Inside the bar, you have the plaintiff and the defendant sitting on the same floor, same level, not separated by boxes. You've got a jury. If it's a trial, where do they sit? A jury box. They aren't there. You have a judge on a raised platform. It's a box. The judge is not there. Really scary. You have the witness box. The witness is not in the court. He's not there. Whatever he testifies is not present in the court.
It's just a show, in other words. It's the stage. If you can get your mind around that, what Jack is telling you, the only two players there are that and the referee, just like a tennis match up in a box or up on a chair overlooking the game, is the judge. And we've heard the judge say how many times, Jack, that he's merely a what?
Facilitator.
A facilitator. I've heard it a couple times, lots of people. What else has he been called?
Referee.
Referee? He says, I'm merely a referee here. He's also said, I'm just a witness. It's interesting. Now, all of you are going, but this judge, he's right in the middle of it. He's on my case.
What happens, though, when either one of these parties in the case, the court, goes into dishonor and will not settle it, the referee turns very aggressive because he's calling the penalty for the dishonor. And he has the authority and the power to execute on the penalty for the dishonor. But the dishonor is these parties are not settling their own case. Now, the reason the jury is there is to observe the fact that the parties in the court are in dishonor. And they're observing as witnesses.
Wait a minute, I thought they were there to determine guilt or not guilt.
They are, but not guilt to the facts of the case, guilt to the dishonor.
Really?
And who's in dishonor, the plaintiff or the defendant? The defendant is always in dishonor. Because doesn't Scripture say, before you as a defendant come before a judge or a magistrate, you must settle the case. In every legal proceeding, commercial proceeding, the defendant is always a trustee. And the plaintiff is always a beneficiary of this trust. And a beneficiary has almost no powers in the trust to do anything. Who has all the power in the trust other than the grantor?
The trustee, right?
The trustee. So the trustee is always a defendant because the beneficiary who's suing the trustee is claiming that the trustee is in breach of his fiduciary duty.
So if the IRS takes you to court and they're suing you for some particular reason, or you get a criminal complaint or a traffic complaint, the defendant is what in there?
He's presumed to be the trustee who has been appointed to take care of the matter.
Competent. He's deemed to be competent. Now he better get that thing. Didn't he get a notice? Didn't he get a summons to court that there's a problem? Now what have you done with that? Just go to court? I didn't do it? I'm not guilty? Guilt, gilden, an Anglo-Saxon word, gilden, to pay. You go in today in criminal, it's not are you guilty or innocent. Are you guilty or not guilty? Are you going to pay or not pay? That's all the judge wants to know. If you don't know how to pay the bill on a criminal matter, it's not going to be good. He'll take care of the payment, i.e. your body being lodged as a deposit in a prison.
So I think the court is just a bank.
The court is just a bank, yes. You can put it in allegorical terms, however that works and fits for you.
But that's all they're doing is monetizing you.
The bench is the bank. You're absolutely right. That the court, in their terms down here, the court absolutely is a bank. It's collecting the money to discharge the debt. This is the dual trust like we projected yesterday, if you recall. And look at what's going on. Remember, you are box 1, 2, and 6. And the government is basically box 3, box 4, and box 5. And they're trusts. And so box 1 and 4 are the grantors, 2 and 5 are the trustees, 3 and 6 are the beneficiaries. Now remember, I just told you that in their public court cases, or in any court case, public or private, that the plaintiff is always which party? The beneficiary, and the defendant is always the trustee, right? Wait a minute. In public down here, 5 is the government trustees. 6 is the straw man, they're us. Who always is charged into the court? Straw man 6, is he a trustee or a beneficiary? It's a beneficiary. So why did Smith tell you that the defendant is always a trustee? That doesn't make sense. But the public is always backwards. The public never does make sense. That's why you people are confused. You don't know who you are, and you don't know how to resolve your court cases, because they bring everything what appears to be backwards. because they're coming after a beneficiary, and the attorneys, who are the trustees in the court, are blaming everything on the beneficiary. But you need to have a trustee as a defendant. For what reason? Because whoever's the defendant has to resolve the problem, right? Can a beneficiary ever resolve a problem? No. But what did we tell you yesterday? Didn't we say if you went to court and you were playing the role of the straw man defendant, do you have a prayer of a chance of winning ever? No. We told you that. Because a beneficiary has no capacity, as a trustee does an accreditor, to discharge the claim. So why do they come and charge a beneficiary, they being the trustees in the U.S., charge a beneficiary into the court? Well, they can never lose their case if you come in this capacity, which is what they seem to want you to do. But we said that if your straw man gets charged, who has to appear? The real man, but a real man cannot appear there. But nevertheless, we said you had to come through box 2, the creditor. Isn't that what we told you? If you don't take on the capacity in these court cases as box 2, you're not going to win ever. If you hire an attorney to represent this defendant in box 6, you're going to lose every time. They will let a couple people go through, just like Las Vegas will let some winners go home. Otherwise, if they took everybody's case or everybody's win away from them in Las Vegas, the game would be up and nobody'd play the game.
Certainly they wouldn't be paying attorneys.
Okay. So. What is box 2? Is he a trustee or a beneficiary? Oh, he's a trustee. Who does the defendant have to be? A trustee. So what they did is they named this guy as the defendant. And anybody that's got a brain left in his head knows that this guy is just an illusion. He is not the real defendant. He is the transmitting utility to transmit the charges back to a trustee. So now the trustee is in box 2. In the real world, what Gordon is telling you is, where is your court? Wherever you are. Who are you? If you think you're the defendant, your court is in the public, and you're bass-ackwards, you cannot win because you're a beneficiary. If you think you are the living man or woman, your court is up here in the Republican box 2, and you better do your court procedure privately in your jurisdiction before anything happens down here in the public. Otherwise, you cannot win.
And your jurisdiction being the administrative process that you're going to be taught today.
Yes.
Okay. If you use the script that Garrett wrote for his ex-girlfriend, and you go in there and you say, Your Honor, I want to plead guilty to the facts, and I'm here to effect payment to settle. You're doing that as number 6, right? But when you sign, you're actually being number 2.
Payment. If she's coming in here, why was she coming in here, and why did Brandon tell her just go in and act like a good debtor? What was she trying to maintain? Her license. Is the license a private right or a public benefit? Well, if you want to maintain a public benefit, you got to be a good little debtor. So stop trying to come up here. Yesterday, did Gordon tell you, under certain circumstance, we tell our people, just go in there and be a good debtor. Stop trying to act like a free man and somebody up here that's a creditor. If you want to keep a public benefit, you got to put on a show in the public.
Or in the case of those people, some of them in prison, where we needed them out for a certain reason on a contempt charge, they can go in there. The contempt charge is rather easy to take care of, But you're not going to do it from a position it was the debtor who made the contempt. It was got to be the debtor that undoes the contempt. So don't go in there and act like box 2, trustee. Go in there and act like box 6, principal debtor, and take care of the matter. That's an easy one to do, because that contempt charge can be discharged by the debtor only. So the things that we teach you, open your mind a little. It's not just you're going to find this. It's not just a square peg for everyone. There's round pegs and there's triangular pegs. Put the right one in the right hole. Picture in your mind, like Jack's telling you. This young lady wanted to keep her license. You can't go in there as a creditor and do that. I had one of the students call me yesterday. I'm down here getting a driver's license. How should I sign this? Just put your name there. Putting UCC 1, 208, 207, 308, 419, whatever, 314, whatever you want to put there, is only going to interfere with you getting a privilege, if you want that privilege. So, and once again, if you understand who you are, it's okay. Are you that name? No. I don't care if it's upper, lowercase, this, that, or the other thing. There's times you use just what we call a blank signature or unqualified, and there's times you put something above it. All rights reserved without prejudice, or without prejudice, or without recourse. There's all sorts of things you use these words and things for. You'll get used to it. Don't try and fit one thing to a situation. Go ahead, Jack.
Jack, this may be a little bit off topic, but would you agree that box 3 can be considered the legislative box, box 4, the executive box, and box 5, the judicial?
No, because they're different trusts in different venues. Box 3 is definitely the beneficiary of the private trust. But box 3 now is really the one that there is a trustee of this beneficial box. The benefits are the estates of all the living people. But they were put in the hands of someone that's going to use those benefits to finance the public trust. And the party that sits here that takes these benefits, that dishes them out here, these people are the shadow government in reality. So this shadow government here is the repository of all of the people's wealth, people being living as opposed to persons being fictions. So the people's wealth is being generated to create a world of persons and illusions to go into admiralty business in order to create benefits for the straw man who is your alter ego down here to receive the benefits in this world of illusion. But they all funnel through the direction of the shadow government. The shadow government has no nation.
The democracy.
It has no people. And it has not been elected or appointed by any one of the people that generated anything into this trust.
Well, its nation is actually D.C. and its objects extending all over the land. And those are very few.
Yeah, there are 3 cities that actually represent that, which is the Vatican legislatively, the District of Columbia executive, and London judicial. Those are the only 3 sovereign entities left, and they're not the whole city. They're a very small section. But they don't represent anyone. Getting back to your question, see what Brandon told her to do is go in there, rip out your checkbook, and say, I'm here to pay. Does a beneficiary pay anything? No. So when she went in there in open court and announced, I'm ready to pay, had the judge in that traffic case or that case issued any judgment against her? No. Why would the judge issue a judgment?
If there was a controversy.
If there was a controversy and the parties had not finished the controversy. Was there a controversy when she stepped into open court and said, I'm here to pay right now? If there's no controversy, she isn't acting like a beneficiary, even though technically the case looks that way because she's a straw man. She isn't in a controversy because she says, Guilty. Let me pay.
Well put, facts are all true. She's not there to argue any of the facts.
Where was the decision made, inside the court or outside the court? It was made outside the court, and she brought the outside decision to the court. The judge did not have to rule except to confirm it. So obviously she made a decision up here with regard to a public license issue down here. She raised a checkbook and said, I'm here to pay. There's no dishonor. Had she waited for the judge to say, well, we're finding you guilty, then it was not decided outside the court. She is in a contempt because she had to rely on the judge to settle something that she didn't bring as a settlement. When she raised her checkbook, was she electing to pay out of the public bank or out of the private bank? Public bank. It's a checkbook. And the judge is seeing, well, she's going to pay in this jurisdiction, which means there's no problem. We will let her keep her license. She's honorable. She's acting like a trustee, even though she's transparent. She's acting for the beneficiary in the trust. So we're going to put her in honor, even though she's using the public system to pay the fine on the public privilege. But the judge didn't sanction her with points. Yes?
What would be the difference? What would be the difference in her sending the payment in? What would be the difference of her just sending the payment in and the judge, they accepting the payment without her?
That is a very good question. In the public, where does the court operate? In the courtroom, in open court. If she sent the payment in, where was the transaction transacted? Outside the court administratively. For instance, if there is a criminal process going down against a straw man, the first thing the court will do, since it's setting a contract, like we said yesterday, it will establish the parties. Who's here? Who's representing who? Then the court will attempt to set the jurisdiction. The court judge wants to always direct the contract toward the public venue jurisdiction, unless you are capable in honor of bringing the jurisdiction of your contract into the private. He will attempt at least 2 to 3 times to get it here. If you're good and you're in honor, he will go, well, let's just go on to the next thing, which is leaving the field of battle. When one of the contestants leaves the field of battle, what does that mean? He's defaulted, and the win goes to the other side. So remember, there's such a thing as the contract or the court case, and like Brandon was telling you yesterday, there's little agreements that you go to along the way, and the summation of the agreements then determine the outcome of the whole contract. So one of the agreements is, who are you as a party? Another agreement is, what jurisdiction are you holding your contract in? And as these agreements get established, they move on in the overall direction of settling the commercial claim. So in these criminal cases, the judges go, well, who are you? Are you here properly? And then tries to set a jurisdiction. And then the judge says, we're here today not for the trial, we're here for first appearance arraignment. How do you plead to the charges? But before he says that, there's something very important. Do you waive the reading of the charges? What's that got to do with anything? If they don't read the charges publicly into the court case, they're not there.
The record. They need to read them into the record for you to get your remedy.
They're not there. because the court case is the proceedings in the open public hearings. It's got to be there. When you waive it, let me put it this way. If an attorney is appearing for your defendant, your straw man, or if they appoint an attorney to represent your straw man, then you are incompetent and the judge will always direct his questions to the attorney because you're incompetent. You cannot answer the question having an attorney on the record for you. The attorney will always waive the reading every time. What happens to this case in the criminal when the attorney waives the reading? What just happened to the case? Say what? Guilty? Oh no, there's no guilty yet.
He only says one thing. Your attorney can only say one thing, not guilty. My
No,
client's
we're not
paying.
at the pleading yet. We're at the issue of waiving the reading of the charges openly in court. After he waives them, then they will say, how do you plead?
Giving up all his rights.
Giving up what rights? What public rights? What happens to this case if they don't read it into the record? That's going to be different if they do read it into the record.
One's the public side, one's the private side.
You got it. Did you hear what he said? One is the public side and one is the private. If they read the charges into the record, what are the charges?
Let me ask you a question, Jack.
If they don't read them, what are the charges? Private.
I understand that about a criminal situation, but let's say if I'm in a courtroom on a mortgage and there was a plaintiff and I'm the defendant, so to speak, should I call them to read the charges into the record on a civil case?
In a civil case, do they ever?
No. Should they?
So every civil case is private. It has nothing to do with public.
Could we demand they read the civil case as in charging me with not paying the mortgage or
let's
something?
go back and decide what this means. We were talking last night, some of us, and we said this domain up here is private. And we said this domain down here is public, right? But is there such a thing as private-private, private-public?
Public international law, private international law.
Could it be that your private affairs might affect some kind of a public interest, like paying your utility bill on the private side? Is it possible it could be private-private? Maybe a negotiation with Internal Revenue Service over some kind of discharge of a tax liability involving the straw man. Yeah. Down here, we could be public-public, and we can be public-private. Now remember, as far as their charges are concerned, aren't their charges coming out of the public? Yes. But what we just said is if they read those charges openly, verbally into the record, in the court case before the pleading, that's a public-public prosecution. If they don't read them, it's public-private. What the hell is the difference? What is the purpose of that King's Court? What are they there for?
Raise revenue.
Raise the revenue. So if it was a public case, where would the revenue go? To the public. If it was a public-private case, where would the revenue gained by that conviction go? Private. These are admiralty cases. It takes two things to bring a proper charge into the court. It takes a security offer and it takes a bond, because you need both the title and the money.
What did we say a security was?
Agreement between the parties. They're making you an offer in the charges.
Any evidence of debt or ownership.
Okay, so in the charge, they've got to bring a monetary statement or invoice, what you need to actually fulfill the contract offer of the charge. How can they bring a charge against you? You murdered someone. Oh, we're just going to jump to you die. There's no remedy? What did Pinocchio say to Shrek? There's got to be an escape clause. The escape clause is the monetization of the security agreement so you could pay the debt and go home.
It's said in a court case, a judge quoted thus, "Few, if any, intelligent and well-educated laymen are schooled in the science of law, and if charged with a crime are capable of determining for themselves whether the indictment is good or bad. They are unfamiliar with the rules of evidence, lacking both the skill and knowledge to adequately prepare their defense, even though they may have a perfect one. They require the guiding hands of counsel at every step of the proceeding. Though they be not guilty, they face the danger of conviction because they do not know how to establish their innocence. If this be true of a man of intelligence, how much more true it is of those without adequate schooling and experience." So what Jack's telling you is, wow.
You have no idea what's going on. Did you realize that when the straw man got the ticket, he was supposed to stay completely out of it and you were supposed to go to your trustee to resolve it? Did you understand that before this weekend? Because you're down here trying your damnedest to put some paperwork in that court to cause something to go away, or you're ignorant and you're hiring an attorney, and the attorney representing the beneficiary has no capacity to do anything other than to negotiate an agreed settlement with the trustees, which is what about 99% of every criminal court case ends up being. A negotiation between these two parties to pay some fine or do some time so that you can set off the damn charges and let it go away because you have no concept of who you are, what you're doing, what they're doing, or how to get your remedy.
Now you said set off the charges, Jack. You didn't say pay, right?
Well, if you go to prison, that's involving living people, and that's a set-off because they're actually coming to the equivalent of your asset account to do that because you're just in there as the bond or the surety, security for that payment as you work it off in time. So what you got to understand is going on here is if you waive the reading into the court, it is not a public criminal case. So the state, the city, the national government does not get the profits. If they read it into the public, the next thing that you would request that the judge do is have the prosecutor bring in a public bond. A public bond is a debt instrument, not an asset. And the public bond is the monetization, the statement that you can do an acceptance for value to set off, settle, and close.
Hey, Jack?
But these courts are not doing anything for the government. They're doing everything for private investment.
I keep hearing you bring up this word monetize or demonetize. Does that mean to make legal tender?
It means to set it off with some accounting that comes from a bank in the public or a bank in the private.
When Jack tells you to they're going to monetize or you're going to monetize the banker's acceptance, it's to make legal tender.
Legal tender is that which legally has the effect of discharging or setting off a debt. They can't tell you to use a public bank or a private bank. The choice is yours. And so in any of these examples, Gordon's been talking about a court case. Do we care what it is that is charging your straw man? Do we care whether it's a murder? Do we care whether it's a robbery? Do we care whether it's a tax payment that wasn't made? Do we care whether it was a lack of payment in support of your child in the divorce hearings?
Are the facts on the moon?
It's just a debt. It's an account. All you have to do is agree to allow them to zero that account.
Now, they're not going to do it just voluntarily and ha got us. It's going to be a very animating contest for them to get you into the public side and off at a private side. They're not going to, and they're never going to admit you're right. Not through their words, but through their actions they will. So it's a little difficult to get your mind around it. And when Jack's telling you that it isn't just simple as 1, 2, 3, but it is as simple as 1, 2, 3, 4, 5, 6.
If we waive the reading of the criminal charges in the public session of the courtroom on the first appearance, it could even be a traffic case. If you waive them, behind the scenes, the clerk has to put a bond into that case. Every admiralty case needs a bond. If the bond isn't coming from the city, the state, the county, or the Fed, and it's a private case, who's putting up the bond? Who wants to make money off of you? How about Walmart? They'll put up the bond. Whoever puts up the bond is going to make the money. It's going to make the profit off this case. So the profits are going to be shared by the judge, the legal system, and the private investor. That's what the courts are doing. Do you think the courts are funneling any money into the coffers of the city, the state, the county, and the feds? They do not support the states. Where does the state, the Fed, the county, and the city get their money to operate? Is it from taxes? No. Is it from court receipts? Hell no. Where do they get it?
Sales. Import. Tariffs.
They get it from grants. From the grantor, the Federal Reserve. That's what funds everything. State grants, sharing. All your government is already dictated from on top by the Federal Reserve committees. Who's going to get what? Which state's going to get what? How much? For what purpose? All of the receipts that are coming through taxes and all of this other stuff, with some minor exceptions, are going to do what? Pay the private investors. Why do you think they bought these bonds? So the court is not really interested in you creating a problem and forcing them to go into the public. If you had to force them to go into the public, isn't the public pretty much broke and couldn't put up a bond anyway? Most likely.
Are you telling me, Jack, that if I go in there on a criminal case and ask them to read them into the record and then demand the original charging and or accusatory instrument together with the public registered bond in support thereof, they're going to have a little difficulty doing such?
If you understand what you're doing and you can do it officially before the court on the record in such a way of not being in a dishonor, what you're doing now is once that public bond goes in, that's the debt instrument to accept for value, return for value. How can you accept an instrument of debt in a case in which it's private? Because remember, we've been telling you, or if we haven't said it here, your documentation where you settled the case in private, once you get it settled, where does that record have to go? Brandon's going to give you more of that information here as he does his administrative process. But where does that information go once you settle it in private?
Private side.
Goes into chambers with the judge, which is private. If this criminal case is private, where is the bond from Walmart or the investor?
Private side.
In chambers with the judge in the private side. He can see the documents. Can you see the private bond in the public records of the court?
Nope.
They're not there. You waived it when you didn't want it public. You are the captain of your ship, the leader of your soul. If you don't know how to contract and get these people to do what you are requesting them to do so you can handle the outcome, you have no idea what the amount of the bond is in order to do the A for V, to do the acceptance on it. It's all contract law.
How does that change in a civil case?
Okay, we're kind of not on the tape yet. I don't think we heard that. Are you on?
Oh, I can barely hear.
Yeah, try it again.
How does it change
There we go.
going from criminal to something civil?
Criminal is civil with a higher level of dishonor, because obviously when the matter was civil, you chose to ignore it and not carry out your duties. So now the level of dishonor is raised to a point where the penalties for your not doing your job to solve this matter when it was civil have been raised. So a criminal is just a higher level than civil. It tacks on another penalty. So when we're working with people that are dealing in a criminal prosecution, you got to deal with the setting off of the criminal accounts that were set up. But in order to qualify to have those criminal accounts set off and zeroed, you got to go back and correct the foundational problem which always existed back in the civil world with these people before it went criminal.
We kind of tell you a little thing. We say criminal is nothing more than a civil penalty which is raised because the parties failed to resolve it at the civil stage or at the lower stage, what Jack is telling you. Our people that we get out of jail a lot and these contempt ones, what do? We merely go back and fix the underlying contempt. Or this recent gentleman, Bob from New Mexico, Bob Lester, he was on the Monday nights with us. He's in on a federal case. His situation was he'd filed some charges, what's known as tax form 8300s against the judge and 4 others involved in a state case. The feds brought charges against him. And he's in prison. He's not been gone to trial yet. What we did is went in and we fixed the underlying civil dishonor. The problem was he didn't understand that he needed to fix that so that there wouldn't be criminal charges or that the criminal charges could settle.
He needed to cancel the 8300s, which were causing the problem to begin with. He needed to request forgiveness, and he needed to offer that if there were any damages monetarily to the party caused by his civil process, that he would stand behind those in full and reimburse any party that brought forth a claim of damages because of his mistake.
That's what we filed into his case, including he had a public defender. We had to remove that, and interestingly, things weren't going. It still wasn't moving. Once again, we know government always does it right. There was also still a state attorney public defender that had to be dealt with, even though it was a federal case. Rather interesting. So it was a kind of an interesting situation where when we went in and took care of the state one, and he immediately got, within 4 days, was brought back to New Mexico. Settlement was offered by the feds, and he even says on the Monday night they were not very happy about it. But you see, he'd resolved the underlying civil dishonor, and therefore the criminal dishonor could be settled.
Let me do something briefly that I did last night.
Got a question over here, Jack. Too.
Qualify this. Go ahead first.
If the bar is private, can we go in the bar? And that's in front of the judge, right?
The bar is the British Accreditation Registry, and they're doing all their private law in there, which is before the captain of the vessel.
I think he's asking about the bar in the room itself, Jack. Is that what you're asking?
Well, if you go inside the bar, you better qualify why you're inside the bar. In other words, you've got to get their agreement that you're inside their foreign territory, but still maintaining the protections of your jurisdiction.
In other words, you have to, if I'm standing outside the bar, and I say I'm here today...
Mr. Gordon, you're the defendant here today. Please come on in the bar.
I'm here today as the authorized representative for the surety over the defendant, Gordon Hall.
Yeah. You know, that's all nonsense. I'm asking you to get in the bar here today. Are you going to get in the bar, or are you going to be in contempt?
So that I'm not in contempt of this court, I'll enter the bar as the authorized representative for the surety over the defendant merely for the purpose...
Okay. Come on in here.
Let the record show that I'm entering the bar as the authorized representative for the surety over the defendant merely for the purpose of assisting this court in set-off settlement and closure.
Will you please get in the bar here then? I accept any condition you put. Just get in here.
The condition is merely for the purpose of set-off settlement and closure to receive have the public charges or have the charges read into the public record for set-off settlement and closure.
Hall,
let the record so show. I'm coming on in. I'm in. Thank you.
Okay. Now, we can start doing. All he's got to do is make the record and make it apparent that coming in, he's under that jurisdiction.
Now what Jack just did, you notice, remember Jack, we had one of our students, he goes, may I come in the bar with all my rights reserved? The judge goes, come on in the bar, all your constitutional rights are reserved. That was a counteroffer and he went in the bar. He said, let the record show. He had constitutional rights, which we know there's no such thing, merely privileges, and he had some problems.
So we don't want to be in the bar.
Yes, we do,
yes,
if you have an agreement.
Under the proper circumstance. Now, sometimes the judge will be testing you. It depends on didn't Gordon tell you earlier that when it comes to court, you've got to be aware of the surroundings and what's happening right now, because cases are contracts and they move, they're dynamic. We've had judges tell people, get in here. They maintain their jurisdiction. The judge didn't object. Let the record show there's been no objection. The guy went to move into the bar and the judge goes, halt! And then he covers the case with the guy outside the bar. What just happened? The judge doesn't want your foreign jurisdiction into what he's going to do today inside the court. That case is only going to be on the public side inside the bar today. He doesn't need anybody out here that's doing anything in the world of the Republic to be in his court. He's going to put on a really big shoe for the public, and it's going to all be a bunch of bull crap just so that everybody thinks the judge is in total control.
3 short stories for you, on long lines with Jack here. I was in with one of my clients over in L.A. He's sitting in, matter of fact, this was the guy that started teaching me about this stuff in prison. And fast forward like 10 years, this guy was real bright, but he'd been partying, alcohol, and he's kind of a doofus after that, not paying attention to his stuff. We're sitting in court. He says, okay, what do I do, Gordon? He says, I'm here today as the blah, 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 blah. So we're sitting there, and they finally call the case. He stands up, and he goes, I'm here today as the authorized representative. We have some other saying. I'm here today as the paramount security interest holder in all property and collateral. And the judge goes, what? He goes, I'm here today. The judge goes, just come on in. He just walks in. First mistake. Then the judge says, now get over there and sit next to your attorney. And he went over and sat down. Party over. Second witness. He said, excuse me, my son. He says, shut up. He had 4 marshals there. He's doing 17 years right now. He never got out. He didn't understand what he was doing. Number 2, we had a really cool one. We had a couple of doctors go into court. They introduced, and this is the one Jack just told you about. I'm here today, blah, blah, merely for the purpose. Judge says, come on in. Oh, they stood out there and held it. So it gets to be, I won't bore you with a third one, but I mean, you have to listen. Well, the last one is this guy in Arizona on a murder charge. And he says he's going to a competency hearing. Rule 11, they call it in Arizona. And I'm sitting in the gallery and watching him, and we've been doing real good. And he went to the first one by himself and screwed it up. And I wasn't there, and so I go to the second one with him. And he says, I'm here today. The judge goes, Mr. So, just get in here. You know, just that kind of a tone. Just get in here, a little impatient parent type. And he says, get in here. And he backs and he goes, I'm here today as the authorized representative. You know, and then he turns around and stands up facing the judge. And the judge says, now get over there and stand next to your attorney. He walks over and stands next to him. And he says, excuse me, Judge, can I say something? He says, no. He shut up and party was on.
He accepted the attorney by failing to object timely, and having an attorney made him incompetent, so the court can't hear him, and everything now has to go through the attorney. So he volunteered to be the debtor.
You're going to run into this in your cases, civilly or... Everything's civil. When you're in that courtroom, you better know who you are, and you better understand where you're entering.
Let me show you what's going on in the courtroom very simply. We're going to use this diagram in a different capacity right now than we used it yesterday. We used it yesterday to show you a macro of what's going on in society. Today we're going to do the following. This is you, the living man or woman, making decisions in your life. This is your trustee who has the capacity to access the asset bank account on the private side to set off, settle, and close things. Okay? This beneficiary is not now the beneficiary of your estate per se going to the shadow government. This beneficiary is some public entity that wants to get paid. Okay? He wants to get paid like the utility bill that your straw man owes. What you can do is you can literally authorize your trustee to go ahead and either A for V it and pay this guy, or your trustee can elect to draw funds out of the straw man's bank account and pay this bill in the public. If you pay the bill, isn't the beneficiary happy? Doesn't he go away? Yes. Now, what happens if you don't pay the bill? If you don't pay the bill, is the beneficiary ticked off?
3 minutes.
You bet. Who is the plaintiff in every court case?
3 minutes, brother.
A ticked off beneficiary who's going to sue you down in their courts because you didn't pay his bill privately. See, you could pay it private, coming out of your asset account, or you can pay it public, coming out of the bank account for the straw man. But since you didn't pay it, he goes and files a court case down here in the public. The public court case is a reflection of your private process. The living man is the grantor to the trust with all the power. Guess what? The judge is the grantor in the case to a fictional mirror image process which is going to resolve your problem. The trustees down here in the public court case are the attorney for the defendant, the attorney for the plaintiff. And who is the beneficiary down here in the public court case? The mirror image of the beneficiary up there that didn't get paid. So what we're seeing here is the judge has all the power in the court case, appointing attorneys for the plaintiff and the defendant in order to get the beneficiary, the company you didn't pay, paid. What is this thing going on down here? It is a probate court. When do probate courts come into play? When the testator dies. When you did not pay this bill up here on the private side, you're commercially dead. You have either gone out of existence, failed to pay it, or are unable to pay it. You're dead. So what they're doing in a civil case is they're probating your estate. Since they're probating the estate, they named the defendant in their case to be the trust. But the defendant is dead. So if you as a defendant come into a civil case in the public, does the court ever listen to you? Hell no, you're dead. And if you seem to be saying something, all you are is a mere projection that is talking. As long as you don't do it in private, the court will substitute for you. You have nothing to say, no evidence, nothing, you're dead. They probate you and take the assets out of your public estate for the straw man. Your only remedy is, God, it's a miracle. He came back to life. So if you go to the private side and start dealing with this court now has to wait to see if you're going to do what you were supposed to do.
And that's what Jack and Brandon and I are going to go into this afternoon after break here. It's going to be the administrative process to give you a remedy on the private side.
It'll bring you back to life.